165. So we are discussing section 165, under which we have discussed that the abelment by the joint owners that happens when a bailey can return the goods to one joint owner unless there is an agreement requiring the consent from everyone, right? So under section 166 we have discussed about the redelivery without the title. The title means the title on the goods, the ownership on the goods, right? So when we are talking about section 166, what does it mean? It means if the bailor has no ownership, but the bailee, in good faith, returns the goods to them, the bailee is not liable to the original owner or to the true owner, right? So it is mentioned that for example, if a bailor he has no ownership on the but the bailee in good faith returns the good to them, trusting that he is the bailor, then, here in this case, the bailee is not responsible to the original owner for his activity. Just take an example. For example, you are having a house of the 2 BHK flat in which I am staying as your bailee, right? Or I am taking care of your house and I am staying there as a bailee. So, what happens that I don't know that there is some other person who is the original owner. What I think, the person who communicates with me, who takes me to the flat, who takes care of my needs, I believe that that person is the original owner, right? So when if the bailor has no ownership, but the bailee in good faith returns the goods to them, then if the goods has been returned to the original banner or to the original owner, instead of the original owner, the goods has been returned to a third person who is trusted to be the bailor. He acts like the bailor. His behavior, activity, his communication, everything seems like a bailor, right? So it is clearly visible that the bailee can return goods and to just owner, and most importantly, when we are talking about the redelivery, then in good faith returns the goods to them, the bailee is not liable to the original owner, but the bailee is liable to her brother, right? The bailee is liable to the bailor only, not to the original owner. This is mentioned under section 166 of the TP Act. Then comes claim by the third party, which is explained under section 167. And what does it mean? If someone else claims the goods, they can go court to stop the bailor uh, asking them, right? So, when we're talking about the claim by the third party, it means when someone else comes to the goods, they can go to the court and stop the bailor from taking them, right? So, these are the things under section 167 we have discussed, in which it is mentioned that if someone else claims the goods, they can go to court or go to stop the bailor from talking to them, right? Then comes section 162. Then comes the finders, the rights and liability of the finder of the goods that we have already discussed in the last class, right? Moving to the next part, we are talking about the bailor's lines, right? So what does it mean? It means the bailor has the first duty of the bailor is about the particular line, right? The first line speaks about the bailee can retain goods will until paid for the service, like 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 publishing. Okay. So when we're talking about the peculiar liens of the bailee, then it is clearly visible that there is no lien of the belly, right? So when we're talking about the lien of the particular liens, then we're talking about the belly can retain goods until paid for service, and most importantly, like tailoring and publishing also, right? So when we're talking about the belly's lines, then we need to understand that these lines are very very particular in manner, right? So when we're talking about this, the first that must be under section 170, right? Then comes then the second one. The second one, it speaks about under section 167, sorry, 177, which speaks about the bankers, lawyers, and others who can hold the goods for general use unless it is agreed otherwise, right? So when we're talking about the particular lien and the general lien under section 170 and 171, then we need to understand that when we're talking about the particular lien, in this a belly can retain goods until paid for services. It might be tailoring or it might be policing. Okay. Then the next point it comes about the general lien. Okay. So when we're talking about the second person, right? Or when we're talking about the beller's line, or the seller's line or the buyer's line, about that, okay? So under that, I would like to say you, so under that we have discussed about the finder of the goods, that is been explained from section 168 to 169 of the TP Act, right? So when we're talking about the concept of the founder of the goods, so under that we are talking about the finder of the goods, and the writer of the finders. Basically, when we are talking about section 168 to 169, right? So a finder cannot sue for expenses but can keep the goods until compensated, right? So, when we're talking about the small goods can, so when we're talking about the finder of the goods, then we are going to talk about that the finder could not or cannot sue for expenses but can keep going the goods until it's been communicated, right? So, when we're talking about the finder of the goods, we need to understand that the finder cannot sue for expenses but can keep the goods until it has been compensated. Then they can sell the goods. The finder of the goods, he has the capacity to sell the goods by himself. So, in what are the conditions in which the sale can be done? The primary condition, they can the primary condition that um, okay, the primary condition that they can sell the goods. Okay, when we're talking about they can sell the goods, it is clearly visible that the person cannot sue for the expenses but can keep the goods until promote until compensated, right? So when we're talking about the like these things, right? So when we have discussed about it, like the first thing we discussed, finder of the goods, the first two rules has been explained as the fundamental right. So here we have two things. The primary thing is the finder cannot sue for expenses but can keep the goods until compensated. Likely, so when we're talking about the selling of the goods may be perish or lost the value, or the value of the good is two-thirds of the value of the original thing, right? So this is all about section 198, right? Then the next part we are talking about section 168 to 169. Then we have discussed under that about the finder of the goods, right? So this is all about section 168 and 169 we have discussed. Then comes the point of the Bailey's lines, which is explained under section 170 and 171, right? So when we are talking about that the Bailey cannot retain the goods until paid for the services like tailoring or policing, right? So when we're talking about, there is a concept of the beller and the belly. Okay. For example, take that the uh, belly can express, right? The first thing is the belly can retain the good until the paid its services, like tolerating or policing, right? So when we're talking about the particular line, it means a belly can retain the goods until it has been paid or submissive, right? So when we're talking about the belly, we need to understand that the belly can return the goods until it has been paid the services like the trolling and policing, right? So, so under section 172 onwards, we are going to discuss about the rule of the pony and the pledge, right? So when we are talking about the pledge, that means goods as security for a loan. When I am taking there is a loan amount of 50,000 from you, then I am keeping my golden ring near you as a submission, right? So when we are talking about the first thing, that how the place rules has been drafted, right? So the last thing is the definitions. Then we are going to discuss about the place. Okay, place is something which is as security for the loan, right? So when we're talking about the place, it means it has सिक्योरिटी ही होना, पहली बात. दूसरा पॉइंट ये होता है कि द पॉनर इज कॉल्ड द प्लेजर एंड द पॉनी इज कॉल्ड द रिवर ऑफ द and the pony is called is the receiver of the goods, right? So when we're talking about section 172, then we need to take care of three major things. The primary thing is the place. The secondary is the pawner, and the third one is the pony, right? The first one is the definition. Then the second one is known as the uh, the the pleasure of the place, right? And the third one, it speaks about section 173, 177, right? So under section 113 to under section 117, it has been explained about the right of a pony. Okay. So when we're talking about the right of the pony, it retains the goods for the loan, interest, and expenses. Whatever the loan is, whatever the expenses is, or whatever the interest is, that is been covered by the um, that is been covered by the place, right? So when there is any goods as security for a loan is been taken, any kind of the loan is being taken and that is being used as a security, then the person who gives the goods is called the pawnee and the person who receives the goods is called the pawnee, right? So the similar way we have discussed about the point of the bailment and the point of the point under which we have discussed about the place, pawnee and the pawnee, in which we have discussed place speaks about the goods as security of the loan. That means to take 50 lakh amount of the rupees, I have to give bank something. so that I am giving my golden ornaments, that till the time period I have not been back, then keep it and I'll take it from you, right? So when we are talking about the place rules and definitions, it need to be understand that the place has a definition. The place has the goods which is called as a socialized society, right? Then comes the owner's right to section 177 to section 178, right? So when we're talking about the topic about the place, it means the definitions which is explained under section 172. And place as a goods as a security or the loan. The pawners is called the placer and the pawnee is called as the receiver of the goods, right? Then comes section 177, right? So this is all about section 177 to 173 to 177. We have already discussed. Then we are going to discuss about the rights of the pawnee, right? So when we are talking about section 173 to 177, it exactly speaks about the rights of the pawnee. Okay. So when there are the powers and right to redeem, it has been explained under section 19, right? So when we are talking about this, okay, I'll just like these things, how the punner and the pawnee concept will be covered. Those things we have already discussed in details, right? So we have discussed that the pawner is a person who pawns the things without any guarantee, right? And when there is a there is a person in which we know that the pawner and the pawnee, okay, the two things, the pawner and the pawnee, okay. Yes, the first thing, the pawner and the pawnee, they are mutually responsible to each other for their activity. So under section 9 we are discussing about the rights of the pawner, which is explained under section 173 to 177, right? So when we are talking about the first condition, it means the retaining of the goods interest or the dis- expenses, right? The first thing. The second thing is sell goods after notice if provoker deals, right? Then comes the any extra money from the sale, extra money from the sale, and most importantly, when we're talking about the extra money from the sales goes to the pawners only. To whom the extra money goes? It goes to the pawners only, right? So this is explained under section 174 to 175, right? Then comes the most important part, the rights of the pawner, in which we have discussed that the pawner has the right to sell if he has been authorized to do so. Then he can retain the goods for the loan, interest, or the expenses. Pawner is the person who did the place, and the place is the person who the place is the person. Pawner is the person who has taken the place. Place is a person. Love you. So, when we are talking about the place, in which we know that the place is a portion in which the person who is the pawner, he pledges something. Okay. For example, I am pledging you a specific thing. Okay. So the place is goods as security for the loan, right? The place is a portion which is given as the goods as security for the loan. The pawnee is a person who acts as the placer, and the pawnee is a person to whom the specific portion has been placed. Right? This is understandable. Got it? So, when we're talking about further, we have discussed about the rights of the pawnee. We have discussed under section 177. There is another right of the pawnee, that is the right to redeem. Right, under which it has been explained that a pawnee can reclaim the goods before the sale by paying the loan and expenses. Right. So when we're talking about the right to redeem of a pawnee, then we need to understand that the claim of the goods before the sale by paying or expenses, the pawnee can redeem the rights. Okay. So this is all about section 177. Then the another section that comes to the picture, that is section 178 and 179. Okay. So when we are talking about section 178, it exactly speaks that the agents or those with limited rights can place the goods if they're acting in a good faith. Okay. Okay. So special place rules we have discussed, the place by the agents or the limited owners. The agents or those with limited rights can place the goods if they are acting in the good faith. For example, the person who is giving the place or the agent or those who are limited rights, they can place the goods if they are acting in a good faith with the trust. And section 180 and 181, the last portions of the Indian Contract Act, this speaks about the suits against the wrongdoers, which is explained under section 180 and 181, in which it has been explained that if a third party damages or takes the goods, in that specific circumstances, both the bailer or the bailee can sue. But when we are talking about the suing, if the third party damages or takes the goods, both bailer and bailee can be sued. Bailer or bailee can sue the third person, and the compensation will be shared based on their interest. Right. So what does it mean? It means that when we are talking about, for example, there is a person who is the bailer and another person is called as the bailee. Right. So when the one person is the bailer and another person is the bailee, for example, there is the presence of a third person, okay, who caused damages to the instruments, right? So when the third party damages or takes the goods, then in that specific circumstances, the both the bailer and the bailee, they can sue for it, and compensation will be shared based on their interest, the ratio of the interest of the bailer and the bailee on the specific goods that will be compensated, that will be shared according to their interest. This is explained under section 180 and 181 of the Indian Contract Act. Right. So the next provision, we are going to have a summarized discussion regarding the concept of the Indian Contract Act. We are going to have a small revision class tomorrow, in which we are going to discuss the whole Indian Contract Act as a brief. So this is all for today, guys. We can wrap the class here. Thank you. Bye bye. Take care.